welcome back to LSAT Unplugged. How are you?
I'm great. I'm happy to see you again, Steve. Thanks for having me back.
Great to see you as well. Thanks so much for joining. So you host the Law to Fact podcast. I always recommend it to my students after they're done with the LSAT, they're done with applying, they're looking at that summer before law school, what to do, what to expect. And so Law to Fact, you want to share a bit about the podcast?
Sure. So Law to Fact is a great podcast for learning the law. I talk to different professors about kind of doctrinal topics that you'll learn in school. Things like what is the rule against perpetuities? What is an intentional tort? So it's really good at I think of it as office hours where the people in the office actually know what they're talking about. I have another podcast now too called Legal Tenzer, and that podcast is more timely. In fact, we did a podcast about affirmative action ourselves, where I talked to different professors about different issues that are pending sometimes before the Supreme Court or just generally of interest. And they're all on Apple and Spotify and everything else.
Oh, perfect. So I definitely recommend folks check those out. So Law to Fact and Legal Tenzer are the two podcasts that you have going on. Wow, that's a lot. So anyway, Leslie, I wanted to have you on today because there's this upcoming Supreme Court decision on affirmative action. My audience, of course, is applying to law school, and they're very curious to see how this upcoming SCOTUS decision will affect law school admissions in the near future. Just to backtrack a little bit, though, could you share a little bit about what led this court case to arise? What led to the lawsuit to start with?
Sure. Well, this actually dates back to 1970s, and there was a famous case called Bakke, which if you go to law school, you'll learn about in common law. And what happened in the Bakke decision was that Alan Bakke was a dental student applying to UC Davis, and they had a quota that they set aside a certain number for minority applicants, and some minority applicants were admitted with kind of numbers, MCAT and GPA that was not as strong as Bakke. Bakke won, and the court then said you can't have quotas. But the court still left open the opportunity to consider disadvantaged and underrepresented minorities. And then we fast track for 25 years, the court says nothing about it. And then we have the Grutter and the Gratz decisions. These were two decisions that came out of the University of Michigan. One was for the undergraduate school, one was for the law school. They were brought by plaintiffs, but really there is and still is a gentleman who is kind of funding these causes of action. Anyway, so Grutter and Gratz gave the Supreme Court an opportunity to revisit affirmative action. And in those two cases, they said that you can consider race as a factor, but your goal should be to have a critical mass of diverse views in the classroom. So the idea was that if you look to balance your classroom so that there's differing viewpoints, it will be a better educational experience for everyone in the classroom. What was interesting about that case too, two interesting things. The first is that the court said that the University of Michigan Law School was doing it right because they were looking at every applicant holistically, and they were seeing how they all fit together to make a good entering class with diverse viewpoints. Whereas the undergrad was kind of considering race as a plus. They looked at sports, they looked at alumni status, all these different things, and race was one of those things that was a plus. And the courts then said no to the University of Michigan undergraduate school, that you can't have a race as a plus, but yes to the University of Michigan Law School, which said if you consider all holistic factors together, that's okay with the goal of having critical mass. But the other interesting thing about the Grutter and Gratz opinions is that Justice O'Connor, who wrote the opinion, they were decided together, but they're written separately, decided the same day, basically said that it is our hope that in 25 years, we do not need any kind of affirmative action again. She didn't mandate it, the court can't mandate it, but they said that's our intention. And so now it's 25 years later. So we had another case called Fish. It was also Students for Fair Admissions, but versus Fisher. In that case, Fisher was rejected from the University of Texas, Fifth Circuit. Everyone thought, oh no, the Fifth Circuit, because they tend to be very conservative, is going to kill this thing. But the court passed and left everything alone. So now this term, there's two cases pending, both brought by Students for Fair Admission. Again, which is a funded group. They go out and find plaintiffs. One is against Harvard and one is against the University of North Carolina. And they both basically say that they are disadvantaging white and Asian students to the, that they're the disadvantaged groups now because the admissions committees have to consider race as a factor. And if you have to consider race as a factor, it is documented that as a whole, African Americans tend not to perform as well, and Latin Americans tend not to perform as well on the LSAT or the SAT. Well, both actually. So that's what's been brought to the Supreme Court. So everyone is very concerned. Now, they had oral arguments at the end of October. And at the end of October, it seemed to sound like the court's going to say you can never consider race at all. But if they say that, it leaves open the idea that you can still consider economic status, right? And also, here's some other things. One of the conservative justices said, well, what if you write in an essay that you've been disadvantaged? That's something you can still consider. Another thing is, I mean, if you look at someone's social media profile, you get a sense of who they are, right? And that might be something that's going to necessarily fall into the consideration pool. So even if, and this is, I'm not being Pollyanna because this would be, in my view, not a great thing, but even if it does happen and the court says you can't consider race at all, the problem is that schools, I think, have been so entrenched with not relying solely on numbers, that looking at the soft factors, as you say, that I don't think they're going to stop doing that, because I don't think that's in the best interest of the classroom. And I think people recognize that. So I think that what may happen, and this is my opinion with no authority, is that economics may be a factor, right? If you went to a school that did not have a strong financial support, if you went to a school that didn't have resources and things like that, and maybe that's something they want to look at. If you have good enough grades but not the best, maybe if you worked all through school, that might be something. High school, that might be something. Maybe if you were a single parent, like there are things that the admissions committee can look at that aren't race per se. But if you look at only numbers, that's going to yield a very different profile than if you consider these soft factors. So that's where we are today, kind of.
Oh, wow. That's very interesting. So what you're suggesting then is that even if the Supreme Court rules in favor of students for fair admissions and they ban the practice of giving basically additional points to an applicant for their race, if they're from an underrepresented group, that they could still get indications of a student's disadvantaged situation or the diversity they might bring to the classroom through their essays, for example, or through their letters of recommendation, or through an interview for schools that do interviews, or through information publicly available about them online if the applicant were to have made their social media public, for example.
That's true, but let me just correct one thing that you said, which is you can't ever give I don't believe under the current law, the current iteration of affirmative action, that you can give race A+. I think it's more that you say, okay, here's 15 applicants. How are these 15 applicants going to look in a room? And are they going to bring forward diverse voices? Now, to be fair, if you have two people of different races that went to the same school and grew up right next door to each other, and all of the, both their fathers are lawyers, right? And one is African American and one is white. They may have the same voice, right? Because they had many of the same experiences. They may not, but they may. And so there are some ways to recognize diversity that aren't solely based on race.
Right. Now, I guess my next question is, let's say that the school, that the SCOTUS, they bring their decision in I guess it's going to be in the late spring, early summer, expected. Okay.
By the end of June.
Okay. And this is a conservative court. We expect they will rule in favor of students for fair admissions. When would that then go into effect? Would that impact the cycle starting in the fall?
It could, yeah. Yeah, because it becomes the law as soon as it's decided. And that's happened in the past. We've scrambled. I have worked on our admissions committee, and we've scrambled as soon as the court rules the way it does. I mean, this is not like a legislative bill where the legislature signs it and then it has to go to the president, the governor, and then the governor has to approve it. No, once this is the law, right?
Right.
So different states and different schools within different states are going to think about this differently. What's interesting too about this case is that they sued a public school and a private school, right? Because public schools, public entities are clearly regulated by the Constitution, right? Because it's public funds. Private, not quite as clear, but there was a rule. It was called I don't remember the name. It was a conservative college. I think it was Bob Roberts, I want to say, but I don't know if that's right. Anyway, basically they said, if your students accept public funds to go to school, then we can regulate you too. Through the Constitution applies, because this is really an equal protection argument, right? So the idea is that everyone has to have equal protection unless there's some compelling governmental reason and no reasonable alternative. The compelling governmental reason has always been that our educational system is discriminatory, and we're not going to give access to people who need access to schools. And really, in fairness, the whole idea of this too is, and this goes back to Bakke, was that if you educate people from underrepresented communities, they're going to go back to those communities because no one else is going back. So it's really important for many reasons, not just to help the student who needs the extra plus, but to help the community at large. And I think that's one of the biggest things that people don't see. I mean, a lot of people see this is the quintessential, black and white, so to speak, right? It's either you're in or you're out. You either get a benefit or you don't. But it's not about the individual getting the benefit. It's about how that individual is going to pay it forward and the importance of that.
Right. So affirmative action has a ripple effect across society.
Right.
Right. Okay.
I would say if you're applying to law school now, my advice would be write an essay that responds to your experiences of diversity. Now, you can't make that up, right? If you don't have one, you don't have one. But there are things that can make people diverse that aren't necessarily about race.
Right. And I mean, at this point, virtually every law school has a diversity statement as part of their application essays anyway. And
Right.
So this would really give students even more reason to write that essay than they would have otherwise if schools are not allowed to consider race directly, but they can still get insights into your background from your application essays as a whole, especially the diversity statement. That can then be a way for students to get a boost if they're looking for one.
I agree. And, but let me be clear too. And we've talked about this before, Steve. The LSAT is still your best predictor. Affirmative action, whether it's there or not, schools love the LSAT. Part of the reason they love the LSAT is because of its ability to predict your success in law school and the bar. But another part is because U.S. News and World Report crunches those numbers. And they're gonna continue to crunch those numbers regardless of whether the schools agree to participate or not. It's a horrible, vicious cycle. I wrote an article about this called ratings fetishism, but it's true. And so the LSAT is the single most important thing. The other thing I'll say is I think that if you get a decent enough LSAT, like 140s-ish, there's a law school for you. It may not be the law school you want to go to, but there's a law school for you.
No, thank you for sharing all of that. I agree with you completely, of course. Now, I guess my question then is, let's say Students for Fair Admissions wins, the conservative court decides against affirmative action on the basis of race. How would that then, in your estimation or prediction, affect the relative weight given to the LSAT in the admissions process? Would it increase, decrease, not change at all? What are your thoughts?
Well, it's interesting because I thought once Grutter and Gratz were decided, and the court said, particularly at the University of Michigan undergrad, which is huge, the court said that you can't consider it as a plus. I thought, oh my goodness, they're just going to go right and rely on just the numbers. It's the easiest way, right? Let's just look at those numbers, and that's all we're going to do. but that didn't happen. Schools really do give it their all to make sure they're admitting the most qualified candidates, and the most qualified candidates are not necessarily the LSAT alone. So I guess what I'm saying is that I don't think what's going to happen is they're going to say, oh, now we can only look at LSAT and numbers. It's not going to be a complete meritocracy. I don't believe that. I think that there will be other soft factors that will be involved, because law schools want to educate those who are interested in coming to law school and those who we think will be good lawyers. And the LSAT and GPA alone isn't enough to decide who's going to be a good lawyer.
Right. Of course, they want people who will add a diverse voice to the classroom, a unique life experience they can bring. That's why they are interested in the resumes. They are interested in the application essays. Of course, I do think that there is, in a general sense, there is some sort of bar where like Harvard's not taking a lot of people with 140 LSAT scores, right? They do want to see certain numbers, but that alone is not going to do it if the other soft factors don't line up, right? I do have a question.
And there's two things I want to say to that. The first thing I want to say to that is every law school has a floor of LSAT number. So you have to get over that floor to be considered. And that's where you're really, in many ways, it's you and someone else with the same number, and then they're going to decide which one. The other thing to think about, and I think this is really important, is that law schools are small. They're much smaller than many undergraduate schools. So it's not as great a burden for the law school admission committees to look at the soft factors. In other words, they have people who work in their offices, and they can look, they have the time, because there's, maybe there's 3,000 people applying for, 400 seats versus hundreds of thousands of people applying for 50,000 seats. So they do have time for that.
Right. Of course, they want to see that too. Yeah, I think you're right that the smaller group means that each individual student matters more in terms of shaping the personality of the class as a whole, right?
Right. I think that's true.
I do have one question for you. Since you brought up the rankings there, I mean, there's been some speculation ever since Yale and Harvard announced they were pulling out of or participating in the U.S. News rankings. They were going to stop submitting data. Of course, they can still be ranked. Yale and Harvard and others, I mean, there was some speculation that maybe the reason they were being so vocal and making such a big statement about withdrawing their participation in the rankings is that the SCOTUS decision is coming out in this admission cycle. So maybe they were signaling in a way that they're going to place less emphasis on the numbers going forward so they can focus more on creating a diverse class.
Well, I actually hadn't heard that, so I can't, it makes sense, I guess, but I don't know that one thing necessarily relates to the other in that way. I do think that numbers drive those who want to report to the U.S. News how high they're going, right? But I've heard, first of all, that the U.S. News is still going to rank people, and if they can't get the numbers from the law schools, they may be able to get them another way. I don't know if they can, but that's what I've heard. And then the other thing I said is that I don't think the schools are leaving U.S. News because of the affirmative action cases. I don't think there's a nexus there, but I think schools will do what schools can do regardless of U.S. News.
I get the sense, though, that basically these schools, even if race-based affirmative action is off the table, through these soft factors, they can still consider who they want to bring into the class. And rankings or not, they can consider applicants basically the same as they would otherwise. In a sense, they can't focus on race explicitly, but they can still deliberately shape the class they would like with the emphasis on the numbers versus soft factors they would like either way. So in reality, then I guess I'm getting the sense that this decision may not actually impact admissions that much.
I think that's fair. And I think, I have to say that to me, it's really economic disadvantage that it's all about. And that if you go back to the Bakke decision in 1978, that there was huge recognition. This is only 15 years after the civil rights movement. And there was a huge recognition or a general belief that your economic status was related to your race, right? And while that's still true today, I think that it's not as true, hopefully. as in 1978. So the the court's basically saying that the Equal Protection Clause says you can't treat people differently based on race. But they're not saying you can't treat people differently based on economic status. And they're not saying that you can't treat people differently based on experience. So there's still room to evaluate and to cultivate a class that will include disadvantaged people, just not on their race alone, if that's what the court says.
I see.
And I just want to be clear, like going back to the Equal Protection Clause, and this is important to listeners because they're going to go to law school, right? You're all going to go to law school. But you study with Steve, you'll definitely go to law school. But the point is this, the Equal Protection Clause says you cannot have a race-based program, right, if it can't survive what's called strict scrutiny. Strict scrutiny means there has to be a compelling governmental reason to have this and no reasonable alternative. The court is likely to find that there's no compelling governmental reason, which is really unfortunate. But if they find there's no compelling governmental reason to admit someone based on race, they're not saying that there's no compelling governmental reason to admit someone based on anything other than LSAT and GPA. They're just, what's going to happen once this decision comes out, if it comes out the way everyone thinks it is that the admissions offices are going to have to go back and figure out what it is that they're looking for other than race to create the kind of class that they want to bring into the law school. And I think there are things to find.
It certainly sounds like it. So it certainly sounds like they could, leaving race aside, you mentioned economic circumstances, economic hardship, economic disadvantage, diversity of experience, diversity of life experience, diversity of viewpoint experience, the extent to which an applicant could share details about that in their application and make it visible to admissions officers. That's a way they could still benefit from an affirmative action of a sort, even if race-based affirmative action is off the table.
Right. I think that's true.
Okay, so then I'm supposing that listeners who were hoping to benefit from affirmative action, who may worry about it going away with a decision in the summer or late spring, we could still give them hope that there is a way for them to benefit in the application process that's not going to be purely numbers-based for anyone applying to law school this fall or beyond.
I think that's an accurate statement. The accurate statement is that your letter of recommendations will count, that your past experience will count, that your personal essay will count. And so there are things that matter in addition to just the LSAT and your GPA.
Okay, fantastic. Well, that's great. I know that's great news for a lot of listeners, and I'm really glad that you were able to share all of this with them. Is there anything else that you would like to make sure that we share with everyone out there before we sign off? I think we've kind of covered it, but if we missed anything, let me know.
No, I think we did cover it too. I guess as a law professor and somebody who has been on the admissions committee, I want to say, do not have any typos in your admissions statement. You think I'm kidding. They're there all the time. And that is worse than anything. That's even worse than a good LSAT number, because faculty who are looking at you want to know that you have the professionalism to become a lawyer. So my suggestion is study hard for the LSAT and make sure that the rest of your application is really strong.
You heard it, folks. Study for that LSAT and proofread, spell check your application essays. Have someone else or multiple someone else's take a look at it.
Yep. Grammarly is your friend.
Yes.
Anyway, thanks for having me, Steve. It's really
Thank you,
wonderful.
Leslie, of course. And again, the podcast, you have Law to Fact, Legal Tenzer available, Apple Podcasts, Spotify, and I'm assuming everywhere else as well.
That's right. Thank you so much.
Awesome. Thank you, Leslie. Thanks for tuning into the show. Please subscribe if you haven't done so already to be notified of new episodes as I release them. And feel free to reach out if you need anything at all as you move forward with your prep. I'm happy to help however I can. In the meantime, I'll wish you all the best and take care.